Hello everyone. ADR, Alternative Dispute Resolution, refer to non-courtroom ways to resolve legal dispute. ADR include mediation, arbitration, and negotiation. These methods are less formal, stressful, and private than court. ADR offers save time and money. Each party is important in mediation. Mediation, arbitration, conciliation, negotiation, and transaction are ADR methods. Let's talk about arbitration. An arbitrator hears both sides' agreement and evidence and make a binding decision in an arbitration proceeding. Arbitration has looser evidentiary rules than trials. Binding arbitration parties agree that the arbitrator's decision is final, cannot be appealed. Non-binding arbitration parties may request a trial if they disagree with the arbitrator's decision. Then, mediation involves a neutral third party, helping the parties to a compromise. The mediators help parties communicate, not decide the case. Mediation may resolve family, neighborhood, and business disputes. Next, negotiation resolve most conflict. Negotiation is usually tried before arbitration or mediation. Negotiating parties can meet face to face. This method put dispute resolution in the hands of the parties, which is main merit. Did you know Malaysian most popular ADR method include arbitration, construction, adjudication, and mediation?
Hello everyone. I would like to discuss the various types of alternative dispute resolution method. The first ADR will be explored is negotiation. Negotiation is a process of dialogue between parties to dispute and to find a mutual acceptable solution. It can occur directly between the party or involve in an impartial third party, such as mediator and facilitator. Negotiation allows parties to actively participate in settling their dispute, avoiding the expense and time constraint of legal process. Additionally, negotiation is typically quicker and less expensive than going to court. There are two major types of negotiation: distributive and integrative. Distributive negotiation focuses on maximizing one party gains at the expense of the others, while integrative negotiation involves both parties working together toward a mutual beneficial solution. Moving on to mediation, which is another widely used ADR method. Mediation involves the inclusion of neutral third party, called mediator, to assist party in reaching a consensual agreement. It is a voluntary and confidential process that promotes effective communication, negotiation, and the consideration of each other's interests. Mediation is often used in various contexts, including business, civil lawsuit, and divorce. Its effectiveness is rooted in the party's willingness to work together and their ability to craft creative solutions, which can foster better long-term relationships. There are two common forms of mediation: facilitative and evaluative. Facilitative mediation focuses on helping parties communicate effectively and develop a constructive relationship to reach a mutually acceptable solution. Evaluative mediation involves the mediator actively providing feedback and suggestions to guide the parties toward a resolution. Lastly, let's explore arbitration as an alternative dispute resolution method. Arbitration involves resolving dispute through the appointment of an impartial arbitrator or panel who render a binding decision. The arbitrator uses their expertise to evaluate the fact and identify the legal issue involved. The decision rendered by the arbitrator is final and binding on both parties. Arbitration is often preferred for its speed and cost effectiveness compared to traditional litigation. However, it may have a limitation such as limited avenue for appeal and fewer opportunities for discovery and evidence collection. Arbitration can be classified into binding and non-binding arbitration. In binding arbitration, the decision of the arbitrator is legally enforceable and there are limited grounds for appeal. In non-binding arbitration, the decision is advisory and not enforceable, allowing the party to explore other dispute resolution options if desired.
Firstly, we will talk about advantages of negotiation. Negotiation can build better relationships. This is because different opinions between those parties can reach one word with win-win situation whenever they point out what they want and what they don't want according to their interest in the business relationship. Second advantages is lasting and quality solution. Third advantages is win-win situation. And lastly, lower cost. We can get lower cost whenever we do traditional way of discussion. As we know, negotiation just involve two parties, which is buyers and sellers. Next is advantages of mediation. Mediation can be affordable. This is because mediation is less than typical time and financial expenses of litigating a disagreement. Usually, the charge for the mediator is less than lawyer charge. Second is mediator helps to reach conclusion. And lastly, confidential. This is because in discussion time, we will just have buyers, sellers, and mediator.
The last part of advantages is advantages of arbitration. Arbitration can be flexible and efficient due to arbitration date is typically double within a few months compared to court cases, which is take many years to solve. Arbitration can be less complicated because in arbitration processes, the rules of evidence may not be rigidly followed in court cases, which means it can be much simpler to admit evidence. Mostly, arbitration cases is less expensive than litigation. This is because the procedure in arbitration will be reduced and more quickly compared to court proceeding. Therefore, attorney fees are reduced.
Next is the challenge of alternative dispute resolution. In negotiation, there are three challenges, which are power imbalance, lack of legal structure, and communication challenges. Firstly, power imbalance. Difficulty in negotiating when there is a significant power disparity, with the stronger party dictating terms and leaving the weaker party at the disadvantage. Secondly, lack of legal structure. Absence of formal legal enforcement in negotiation, which can make it challenging to ensure compliance and settle issue efficiently. Lastly, communication challenges. Obstacles such as language barrier, culture differences, and emotional tension that hinder effective communication, potentially leading to misunderstanding and difficulties in finding mutually satisfactory resolution. In mediation, there are also some challenges, which are firstly, unwillingness to participate. Its success depends on both parties' willingness to actively engage and collaborate. If one party is hesitant or combative, the mediation process may fail. Secondly, power dynamic and imbalance. Power imbalance can affect fairness, especially when one party has more influence or control. Mediators need to address these dynamics to ensure equal participations. Lastly, failure to reach agreement. Despite mediation effort, parties may be unable to reach a mutual acceptable agreement due to significant disagreements in positions, interest, or value. Additional tactics may need to be help find common ground. In arbitration, there are several challenges. Firstly, limited applicability. Not suitable for all cases, especially those involving complex legal issue, public policy concern, or matter of great public interest. Secondly, lack of appeal option. Finality of the arbitrator's decision with limited avenue for appeal, potentially limiting a party's right to a comprehensive review. Lastly, potential arbitrator bias. Risk of partiality or bias, which can undermine the credibility and fairness of the arbitration process. Institutions have ethical norms and vetting processes to address this concern.
Example of cases that have happened in ADR, the first one is on arbitration. So one of the cases that have happened recently is Kindred Nursing Centres Limited Partnership versus Clark that occurs in 2017. In these cases, Olive Clark and Joe Wellney resided in Fulton Circle Care owned by Kindred Nursing Centres in Winchester, KY. Prior to facility arrival, they nominated family reps with significant bargaining authority. Janice Clark and Beverly Wellner, as representatives, signed an arbitration agreement for Olive and Joe's stays, resolving any potential issues. Olive and Joe died in 2009, and Janice and Beverly sued Kindred Nursing for their loved one's death due to the nursing home errors. They wanted compensation for harm caused, and Kindred Nursing proposed arbitration to settle the dispute. They agreed and signed some papers for this. Court dismissed and opted for arbitration. However,
The latter followed the same legal rules set in Ping versus Beverly Enterprises Incorporation, a company name in a Kentucky court ruling found that a power of attorney cannot compel an individual to use arbitration against their will. KY's highest court upheld lower court ruling. The second case is a case on negotiation where Virginia Railway Business System Federation number 40 that happened in 1937. In 1927, American workers formed System Federation number 40. This union was in the AFL. Federation sues Virginia Railway on behalf of workers. In 1934, workers sought train company approval for designated representatives. The group sought aid from the National Mediation Board, formed for train-related legislation. NMB declares Federation the official voice for railway workers after election victory. Union sues Railway in Virginia over lack of communication. Union seeks Railroad Corporation. The Federation cited a 1934 railroad law requiring collaboration with authorized union reps. Railway should communicate with Federation. Railway exempt from the rule. Congress did not intend enforcement. Not possible to force agreement for all. They claim it's illegal to compel them due to the Fifth Amendment. Court orders railway company to consult with the Federation on rules, pay, and work. The railway company can't form a troublesome group for the Federation. The Fourth Circuit Court affirmed the lower court's decision and top court to hear the case. Lake Michigan, USA mediation that happened in 1996 is the example of mediation cases that have happened. During this case, US government debates Lake Michigan water use. Overdrawing water can harm nearby lakes. From 1920 to 1995, the US Supreme Court heard over 4 disputes on this issue. In 1995, a US Supreme Court disagreement occurred. 8 states and US government resolved it collaboratively. They agreed on costs to divide it. Within a year, they aimed to resolve the dispute permanently. 8 states signed an agreement on October 9, 1996. It is in a memorandum of understanding.